Good afternoon, everyone. My name is John Gallo. I'm the CEO and Executive Director of Legal Aid Chicago. Welcome to our third annual webinar series. Today's session will be on the implications of cannabis legalization in Illinois. Now, to get started, I'd like to introduce our host from our sponsor, Kirkland & Ellis, Aisha Laviniere. Aisha is also a board member of Legal Aid Chicago. So Aisha, I'll let you take it from here.
Thank you, John. Hi, everyone. Welcome to today's webinar, kicking off the series of what I think are very interesting topics with a very interesting topic. I just want to welcome you all to this webinar in particular. I am excited to be here. I'm excited to hear what Legal Aid has been doing in this area. And I just want to tell you a little bit about my firm, Kirkland & Ellis' support of Legal Aid and how we really believe in the mission and the attorneys and the staff at Legal Aid and what they are doing. So Kirkland has devoted over 8,500 hours to Legal Aid directed pro bono work. Over almost 300 attorneys, over 60 of our staff have worked on Legal Aid matters, and that number I assume will continue to go up. We've worked on things ranging from educational programming, recently to juvenile expungement programs and a bunch of others. And we're just excited to be a part of such a great organization and continue to invest in any way that we can. With that, I would like to turn it over to our presenters today. So Regina Hernandez and Melissa Picciola will be presenting today on the topic of cannabis expungement.
Good afternoon, everyone. Again, my name is Regina Hernandez. I am a supervisory attorney at Legal Aid Chicago, and I am thrilled to be with you here today to discuss this incredibly important topic, and more specifically, the new law in Illinois that we are seeing implemented in real time. On January 1st, you might have heard of 2020, the governor signed the Cannabis Regulation and Tax Act into law, which not only legalized cannabis, but created remedies for those who have been arrested or incarcerated because of it, specifically through the erasure or expungement of these records. Now, a huge part of the intent of this new law was meant to repair some of the damage created by the war on cannabis, which disproportionately impacted Black and Brown communities. Illinois specifically has the third highest racial disparity in cannabis possession arrests. It's so significant, Black residents were 7.5 times as likely to be arrested for cannabis possession than white residents, even though that didn't even represent what those percentages were in terms of actual use. And while legalization has been a fantastic step forward, we also need to talk about the law's limitations. So let's talk a little bit about what exactly became legal. With regards to personal use, you must be 21 years old to use cannabis, and there are limits to how much you can have on you at any given time. What that means is 30 grams of flower, 5 grams of cannabis concentrate, and edibles with up to 500 milligrams of THC. This is something you can usually check with the labels that are on products from licensed dispensaries. Now, an important distinction, this applies to Illinois residents only. Visitors who are coming in from out of state can only possess half of these amounts. And I should also highlight that general public use is generally not permitted, with a small and narrow exception for some medical users who can also grow up to 5 plants lawfully at any given time in their home. And really, I can't stress this enough, absolutely no using and driving. And we already know that while actually testing for impairments in THC levels is going to be a bit tricky, law enforcement is still really being very strict about this and enforcing this part of the law. What about cannabis in the workplace? Employers are not required to let an employee use or be under the influence of cannabis while in the workplace or on call. Employers can still have drug-free workplace policies as long as the same policy applies to everyone. And they can still require things like random drug testing, especially when an employer has a good faith belief that you consumed cannabis while on the job or were impaired while on the job. However, an employee can contest that belief that they were under the influence if they actually believe that that was done in bad faith. Additionally, I should note that there are some small protections afforded to medical users, such as an employer not being permitted to penalize you just for having a medical cannabis card, but the laws available are not as clear or as strong as one might like. Cannabis legalization when it comes to housing is incredibly complicated. Any person, business, or landlord can prohibit use on private property. If you live in federally subsidized or public housing, this is something that is particularly challenging when it comes to the new state law really having to fight it out with federal law. Generally speaking, because cannabis is still illegal at the federal level, you are prohibited from using or possessing cannabis in one of these properties. While there are many advocates working to prevent eviction and voucher termination with the respective housing authorities, especially with regards to medical users, this still remains a very real issue and a hurdle for a lot of residents, especially some of our most vulnerable residents who actually use subsidized or public housing. If anyone at any time is unsure about whether it's permitted where you live, you need to ask and check the terms of your lease, and when in doubt, just be extra cautious and you can speak to an attorney as well. The complications with federal law do not end at housing. To further stress this point of conflict between the state and federal law, let's talk a little bit about immigration. Generally speaking, if you are not a citizen of the United States, even if you are a lawful resident, you should not use cannabis. There are so many ways that this could be used against you, in particular if you've been arrested or convicted of a cannabis offense. And it's crucial to really understand the wide scope of information U.S. Immigration and Customs Enforcement can consider when making a decision on an immigration petition, including an adjustment of status. If you have used, are currently a cannabis user, there's also some additional complications if you're working in the cannabis industry. It's important to seek a consultation with an immigration professional, especially one who has experience with criminal records matters and criminal offenses in general. Because we know even lawful state users who are lawful residents could be put at risk of some kind of adverse determination, especially with ever-changing immigration law and policies. I want to make something absolutely clear. I'm a big fan of the law, but legalization of cannabis in Illinois is not experienced the same by everyone, even with legalization. During the first year of cannabis legalization, Black people were arrested 2,311 times for cannabis-related offenses, which makes up more than 3/4 of all cannabis arrests in Chicago. That is 3 times as many arrests as all other race and ethnicities combined. Latinos make up the second highest number of arrests. And what I really want to highlight here is that there is a continued need, even after legalization, for structural changes in our legal institutions. And there is still a significant need for legal advocates to continue seeking more expansive remedies and staying informed about the law and its implementation, in particular for the people who are continuing to be impacted by both the past and the present. The potential impact of the criminal records relief written into the new law is significant. While there were initial estimates from the state that suggested around 850,000, 849,000 specifically, cannabis arrests and convictions that would be eligible for some type of relief under the new law, I think any criminal records practitioner would tell you that that number seems a little bit low. Even in just pulling some readily available data from the Chicago Police Department, in just 3 years' time, from 2014 to 2017, officers arrested people 28,245 times just for cannabis offenses that are now currently eligible. This doesn't include anything that falls outside of the narrow parameters of what the law actually provides for. We, just as a practical matter and just from personal experience, we rarely see someone with just 1 or 2 arrests for cannabis. And we see these charges on just about every client's criminal history. So we have a lot more work that we expect to do. Something I do want to be sure to discuss is exactly what offenses qualify for expungement under the new law, because there are some pretty narrow parameters and it can be a little bit confusing. When you determine eligibility for any type of records relief, one of the most important things you need to figure out is whether the arrest resulted in a conviction or a non-conviction. With regards to cannabis expungement in particular, it's not only going to determine if that cannabis arrest is eligible for any kind of expungement relief, but what that process is actually going to look like. Convictions and non-convictions by Illinois law are not as simple as just a guilty or not guilty verdict. Illinois law also factors in the type of sentence that you receive. So that kind of further complicates this eligibility determination that we made. The types of non-convictions you see listed here are eligible for expungement in general, whether done automatically by the state or through a standard petition to expunge. Convictions are really what our focus is on for expungement relief that impacts our clients the most. This is generally where a more proactive and affirmative step needs to be taken by the state, individual, or legal advocate. So convictions, that entire section is what we're really looking at when it comes to the most expansive and really the biggest chunk of relief that is going to impact our residents the most. Let's break this down even further and talk about specifically what the law actually provides for in terms of qualifying cannabis offenses. For minor non-convictions for cannabis possession or manufacture or delivery, what this works out to is if you were arrested for either at 30 grams or less of cannabis on your possession or manufacture with intent to deliver. In addition to the limit of the amount, the arrest cannot be associated with any kind of violent offense, even if the violent offense was dismissed. What this means is if I were arrested for 2.5 grams of cannabis possession, and let's say aggravated battery, even if both charges were dismissed and I was never convicted of anything, that arrest still would actually not qualify for automatic expungement through this portion of the law. And so because of these narrow parameters and restrictions for eligibility, what we at Legal Aid Chicago will do is really add any missed arrests to a standard petition to expunge. Now let's shift to convictions. By far what creates the most barriers for someone with a criminal record just in general. What qualifies for cannabis expungement are misdemeanors and class 4 felonies, class 4 being the least serious of all felony types. Any convictions for possession of cannabis up to 500 grams or manufacturer delivery of up to 30 grams qualifies to either be automatically expunged by the state through what's called a motion to vacate and expunge. This process vacates or undoes the guilty finding or plea, and then orders the erasure or expungement of the records themselves. Similar to non-convictions, these are offenses that cannot be associated with any violent offenses, and things get a little bit more complicated when you're found guilty of multiple counts, including an eligible cannabis offense with different types of offenses. So what's crucial to the work that we're currently doing is the fact that the law permits any individual or legal services provider to file a motion to vacate and expunge at any time. So if we don't want to wait for the automatic process that may or may not kick in for that particular client's offenses, that is something that we are and will continue to actively file with the courts. This is particularly helpful when we do have those cases that involve multiple charges that might be more complicated, or in general, when a client needs relief a little bit sooner. For everything else that does not qualify, rest assured, there are some additional options. So for some of the more serious offenses, so your class 3, 2, and 1 felonies, Legal Aid Chicago will still pursue sealing or concealment of these records through the traditional criminal record sealing process. And if there's any question as to whether or not this might be your category, that's something that a legal professional, including Legal Aid Chicago, can really help determine in terms of eligibility. I know I keep discussing amounts of cannabis and not everyone may be familiar with it. So here is a graphic to help you visualize the amounts that we're really talking about. With regards to general personal use, remember the amount for Illinois residents to lawfully possess is 30 grams or approximately 1 ounce of flour, which is shown here. I also bring this up to show the limitations imposed by the level of convictions and non-convictions that qualify for some type of cannabis expungement, where the limit for manufacturer delivery in particular is currently the amount of lawful possession. And it can be very easy for a possession charge to become a manufacturer delivery charge or to be accused of a manufacturer delivery because the law more broadly says it is unlawful for any person to knowingly manufacture, deliver, or possess with intent to deliver or manufacture cannabis. And even just from my client stories alone, they will tell you this is very, very common. I love talking about our clients in particular and what we could potentially do for them. Really, our main goal at Legal Aid Chicago with regards to our criminal records relief work is full representation for every client and to explore every available option. We really try to focus on goal-centered advocacy, where even if our standard is expungement and sealing, we really want the more practical approach of how can we get that client's goals achieved on a quicker timeline in something more expansive? Is there another way that we can achieve this goal of employment or housing or education? Is there something else we can do? So my staff and I do full and individualized evaluations of each client's records and goals. We not only do cannabis expungement, but general expungement and sealing. And there are some alternative forms of relief that can provide some more direct barriers, we could overcome barriers more directly, such as if somebody wants to work in the healthcare field or is trying to get a specific type of license. So that is something that we will assist with as well. And I'm fortunate enough to work for an agency that has just a wide variety of other legal advocates and people I call my colleagues and friends who practice in 5 other different practice areas. And we regularly make internal referrals for additional issues that come up that Legal Aid Chicago can assist with. I have to talk about why the Criminal Records Relief Project exists and why it is so important to pursue criminal records relief, especially through expungement and sealing. In Illinois, 3.3 million adults alive today have been arrested or convicted of a crime since 1979. That is significant. And I usually point this out for a couple of different reasons. One, to really work to destigmatize the idea of someone with a criminal record and really emphasize how common it is. And secondly, to really put into perspective the sheer number of people that this impacts and the fact that there are well over 1,000 unique, what we call permanent punishment laws in Illinois that limit some fundamental needs, including housing, employment, and education. And what we mean by permanent punishment laws is that there is this concept that the criminal justice system, once you have completed your time, once you have met your obligation to the court and to the state, that's it, your case is closed, you move on. However, that is really far from what actually happens. For people with criminal records, they encounter multiple barriers to things that really just continue to make them feel like they are being really punished in a permissive and punitive manner in multiple other ways when it comes to just living out their lives. And this is something that we actively try to address, especially when it comes to really just establishing some very basic needs, such as having a place to live and being able to be employed, especially gainfully. You're going to hear me say this all the time because it continues to be true. This work is racial justice work. I've already highlighted a lot of the statistics that really emphasize the need for broader structural changes. And when we're talking about criminal records in general, so even outside of just cannabis expungement relief and cannabis law, while Black people represent only 13.8% of the adult population in Illinois, they represent nearly 1/3 of all people arrested or convicted of crimes. That is incredibly significant, especially because when you think about this more, when Black and brown people finish their involvement with the criminal legal system, they are then subsequently stigmatized twofold, often by race and now based on their criminal backgrounds. There is this concept that comes up, especially when we have to argue these petitions in court, that any objection to granting this type of relief once someone has terminated their sentence, once all the requirements have been met, that the state is objecting in the interest of public safety. However, there is significantly more data to suggest that these barriers actually achieve the opposite in terms of leading to conditions and creating conditions that create recidivism and create conditions with regards to poverty, insecure housing, and employment. And I need to break this down a little bit further so you actually understand what a criminal records is, because sometimes a criminal record just in itself, by definition, just looking at the phrase, it can seem to imply that there was some kind of wrongdoing just in general. And that unfortunately is not the case. A criminal record is created whenever you are arrested. So you can have a criminal record even if you never went to court or were never found guilty in a case. Adult records by far are the most serious things to have on your criminal record because they are public record and very easily accessible through third parties, especially a lot of third-party background check sites or the websites that say you could find anything about anybody out there somewhere just by looking up a phone number. There is a huge business in making public information like this readily accessible. And with adult records, these are arrests and cases that occurred once you turned 18 and going forward. I should note, with regards to the topic of the new cannabis law, only adult cannabis convictions qualify for cannabis expungement. It is still unlawful for a juvenile to possess cannabis. And with regards to juvenile records, what those actually are arrests and cases that occurred when you were under the age of 18. There are some exceptions to this, like being charged as an adult, but there are some more significant protections available to juvenile records because they are considered confidential by nature and they are actually very heavily protected in general. But there are a lot of exceptions to actually who can see them if you have not moved to get rid of them in any way. Why are we doing all this? What is the effect? One key thing just to know as more of a know your rights component to this is that an employer cannot ask you about arrests, only convictions, and only after the initial job application process. So after an interview, once a tentative offer has been made, any kind of initial job application process that is just essentially that piece of paper, that first step. However, if your record has been expunged or sealed, you may answer no, generally speaking, to the question, have you ever been convicted of a crime, except when an employer is authorized by law and must conduct a fingerprint-based background check. That is when felony convictions, whether they are sealed or not, will come up. And it's not to suggest that that automatically is going to limit that person's ability to be employed by that type of employer, but it is important that people are aware what can still be seen. I do want to also mention that as of March 2021, even with regards to convictions, Illinois has been making moves to make any kind of protections from discrimination significantly more expansive. So as of March 2021, it has been codified into the Illinois Human Rights Act that there needs to be a more interactive assessment of whether there is a substantial relationship between a conviction, which is, as I mentioned, can be considered, and the job itself. Whether or not this is being actively done is another topic for another day. What I can tell you is that I still regularly, along with my staff, we regularly encounter clients who have been denied employment just on the basis of an existing conviction or of a criminal record in general, because the reality is very few employers really take the time to understand the law, implement the law, and to really make that distinction between convictions and non-convictions the way that we do for eligibility. And now for your CLE code, 22 JB 45. I'll give everybody a minute. And it is also in the chat. And I think we're in the clear. And with that, I would like to toss it over to my lovely director, Melissa Pachola.
Well, thank you so much, Regina. It's a pleasure to be co-presenting with you in this way, and of course to be kicking off another series of these wonderful webinars. So, you know, Regina, you gave a wonderful overview of the law and its provisions, and I'm going to shift gears a little bit to talk about some of the challenges with implementation of this law. The law was actually passed in June 2019, so we're actually approaching 3 years after passage of the law, and I think just now we're starting to see some of the promises associated with it fulfilled, though we continue to see some challenges. And one of the reasons that implementation has been challenging is because the law actually created a form of relief that didn't previously exist. You mentioned that what is available is actually a motion to vacate and expunge. The concept of being able to vacate a conviction is not new. It happens occasionally, and it's most typically happening as a result of an overturned conviction on appeal or other types of post-conviction proceedings. However, vacating a conviction does not actually erase or get rid of a record. The record will still be there. It simply changes the disposition that's reported. And so to actually have the record destroyed or impounded so that there's no trace of it requires an order to expunge it. And the provision of the law of the Cannabis Act was essential to actually undoing the wrongs of the war on cannabis. However, the ability to, in a single motion, have a conviction vacated and then expunged was not familiar to courts or judges or law enforcement agency, and caused significant challenges with implementation of the law. We had several experiences going to court personnel and presenting our motion to vacate, expunge, and being told flat out, you can't do that, despite having our copy of the statute ready and available. So the good news is that we're likely past the period of adjustment and education, and these motions are now being heard and successfully granted. And so to help streamline the process for petitioners, most of these motions are being heard in Chicago, even if someone was arrested in a suburb. And for those of you who may not be familiar, that's actually a significant change. In most situations, you have to file in the suburban district if that's where you were arrested, and you can only file in Chicago if you were arrested in Chicago. This does create advantages for our clients because we've got one judge who these are mostly heard in front of, who's familiar with the process, who understands the law and its provisions. And they've created a process in District 1 so that these can be heard and they can be heard relatively smoothly. However, the downside, and it's a significant downside, is that the court in Chicago is under-resourced, and therefore there is a backlog of cases, not just cannabis cases, but for regular criminal records relief as well. And so what this means as it currently stands is that we are not able to get these cannabis cases heard, or at least presented to a judge, for 12 to 14 months after filing. And as you are probably all gasping at your computer screens, this is a significant burden for our clients and our client communities, and something that all parties involved are concerned about. There are a group of advocates and court personnel, including judges, working to figure out how we can expedite these cases and to shorten, or at least remove or shorten that backlog that exists. So there are some efforts being made here, but the reality is actually a very significant wait time for our clients. And so what happens after you get this on file is that as with general expungement and sealing petitions, after filing, certain entities are provided notice of the petition and are given the opportunity to what is known as object. They can basically say these objections can be based on a number of things, including that you're not eligible for the type of relief that you're seeking. But as Regina mentioned, most often the objections are actually related to what are known as public policy or public safety objections. And in those cases, there's actually supposed to be a balancing of interests between the petitioner's benefit in having the record expunged or removed or sealed, and the public's interest in knowing about the existence of a record. And public can be interpreted a number of ways. Most typically would be those who typically look at those records, that being employers and other types of places that often run background checks. So when there is an objection, in most cases, the judge will hold a hearing And the petitioner can present some mitigating evidence of the types listed here, things like letters of reference and personal statements about what happened and how it has impacted them. Now, of course, these objections are not nearly as common on cannabis convictions as they are for other types of criminal records. But it's important to note that when there is an objection, the petitioner is required to come up with proof as to why they should get this type of relief. And importantly, the judge still has discretion as to, even under the cannabis law, to grant or deny the type of relief that the client is seeking. So as it's set up, there's a potential for the client to have to think about the circumstances of the case, even if it was many, many years ago, and even despite provisions in the law which make it seem like this is something they're entitled to. As Regina was discussing the various types of relief and the eligibility for it, many of you may have become overwhelmed. The reality here is that figuring out eligibility is challenging for many people, including our clients. And there are other types of barriers that exist as well. For example, there may be costs to travel to court to file. You may be required to take time off to go to court dates, and there are other types of issues. The other thing, as mentioned in the previous slide, is that proceeding without a lawyer when there is an objection filed can be very challenging, right? This will become an adversarial proceeding where the state's attorney says something and then you are expected as the petitioner to defend your petition. And so not having had legal training can be very challenging when faced with that particular type of circumstance. Additionally, there are other process issues that put up barriers. Obviously, we've mentioned that backlog, but also thinking about how to actually find the dispositions that you need to know to figure out if you're eligible. Getting access to your records and making sure they're accurate is not an insubstantial task. There's also the requirement that these actually be filed in person. The availability of e-filing is not very common at best, is how I would phrase that, as we currently are in this situation. The other thing is that, of course, there's some lack of notice issues that come up because of an overwhelmed court system. So it has been challenging for Legal Aid Chicago, when we are attorney of record, to make sure that we get notice of everything that happens in our cases. And you can imagine how difficult it can be for someone who is more transient. For example, what if they move in the year between when they filed their motion and then it gets heard? How will they get notice? And will the court be able to proactively tell them when there's a hearing coming up? This is, as a legal aid provider whose job it is to figure this out. It took us about 2 years to really get these ready and understand what the court was going to be requiring of us to get these on file. And so certainly this is a process that could become virtually insurmountable for the self-represented litigant and other people who might be eligible for relief. But we actually had a client who successfully navigated this process. Lionel was somebody who had heard about the law in 2019 and had correctly determined that he was eligible for this type of relief, of a motion to vacate and expunge. The conviction associated with this particular case had been holding him back from employment, and so he was eager to get it removed from his record. So in 2021, when things were still relatively confusing as to whether courts were open or closed and where your court date would be and how you would get a court date, he actually filed on his own cannabis motion. And you can see an image of it on the screen. And the thing that I want to point out is that the substance of the motion really did say vacate, conviction, and nothing else. But the reality here is that getting the motion on file and not being told you can't file this, and getting a court date and a time to appear in front of a judge was actually the really hard part. That was the thing that was insurmountable. After he appeared in court and the judge told him, hey, you should probably have a lawyer for this case, he was able to find his way to Legal Aid Chicago through one of our referral networks. And so we amended the motion to provide more technical detail about what exactly he was asking for and why he was eligible. And through Regina's persuasive advocacy, we're actually able to get it granted. But the story here is really about the client's own resilience and what it took in the face of a challenging court system to remove this particular barrier. Thankfully, the legislature, as part of the Cannabis Relief Act, actually set aside some money to provide legal assistance who do need help in this process. And Legal Aid Chicago is proud to be a member of what is known as the New Leaf Network. The New Leaf Network provides screening and then referrals for representation to clients statewide who need help navigating this process. And so that could mean having a consultation with an attorney to talk about what is on your record. They'll actually do a little bit of research to determine if you're eligible under the law, and then they'll make a direct referral to one of the providers in the network to be able to consider your case for representation. And part of the deal here is that we have agreed to represent people who are referred to us in this way. And so one of the things that was sent out to you as part of the materials for this webinar was actually an op-ed from some of the members of New Leaf encouraging people to use this process. And so I encourage you to publicize the availability of this network broadly and to encourage people to call and be screened to see if they can be eligible for this type of relief. It's a really good service and something that can be very beneficial. And so when thinking about the cannabis law, and in particular its expungement provision, we all can see that they hold so much promise in helping to undo the wrongs of a broken system. But it's also important to remember that, in particular, I have to be honest about where I sit in a position of privilege, who have education and whose race does not make me somebody who's likely to face these kinds of barriers. And so when we engage in criminal records relief work and we explain to somebody that the process associated with expunging your record involves asking a court to do that, what we're having to do is asking our clients to place trust in us and in a system that has often turned its back on them. And I think this is a particularly important moment to consider this in light of the events of this weekend, and also in Buffalo, and also coming up on the anniversary of the murder of George Floyd. And I think what we see ourselves in this process is that we are people who are proud to stand with our clients in assisting them through what can be a challenging process, what can often be re-traumatizing, and helping them remove those barriers so they can be free from their record and able to sort of move on. And so I want to thank you for taking the time to spend some attention on this very important issue and hear about some of the barriers that our clients are facing in this process. We're just so thrilled that you took some time today, and we're happy to turn it over to John Gallo for some closing remarks.
Thank you, Melissa, and thanks for your inspiring comments, and to you and Regina for all the fantastic work you're doing to lead us in this space and to lead the legal aid community in this space. This is my opportunity to talk to you all very briefly about the different ways that you can work with us or support us. So first of all, of course, we're interested in your supporting us financially. So if you're interested in donating, go to our website and go to the link which provides the ability to donate. And of course, we'll take your credit card anytime. You can also, if you would like, and with a company or law firm and you want to sponsor us, please do so. If you've seen on the side and the margins throughout the presentation, we have a robust list of law firms and companies in Chicago who are sponsoring our work. If you have been paying any attention to those names on the list and don't see your firm or company please suggest to your firm or company that they join us in sponsoring us. Our luncheon, our annual luncheon, is at the Palmer House. It's on June 14th. And if your company or firm sponsors us, one of the benefits of that is you get seats at the luncheon, which is at the Palmer House. Third, join our ambassadors board. It used to be called the Young Professionals Board, and it was changed to Ambassadors Board because it's become such a big and wide-ranging and robust group. There's no requirement to join other than that you want to be part of the board. So again, go to our website, look at our Ambassadors Board link, and make the appropriate connections, and you can become part of our Ambassadors Board. And last but not least, we really would love it if you'd volunteer with us. You've heard from two of the folks who spearhead our volunteer work in Regina and Melissa. Melissa leads the charge in that regard. She and her team have put together an extraordinary, wide-ranging number of opportunities for volunteering. And you can volunteer regardless of whether you're a lawyer or not. And if you are a lawyer and you think, well, I have to be a litigator to volunteer, no, you don't. There are many, many opportunities for transactional lawyers to work with us, and the expungement space being one of the main ones. So, so we'll take transactional lawyers, we'll take paralegals, we'll take people who are not affiliated with law firms in any way, and we'll find a place for you to help us. That's the update. And I'm now going to turn it back over to Melissa to do the Q&A.
Thank you, John. And so we've got some really good questions here from our astute attendees. And so Regina, I'm going to ask you some of these and then ask you to primarily answer them, and I'll jump in as necessary. So we have a question about growing cannabis. And so is it illegal to grow cannabis if less than 30 grams, or does the statute prohibit growing it altogether?
You can only grow if you are a medical card holder, and the limit is 5 plants, I believe, still up to 5 feet. There are some very specific details that go into it, but generally speaking, recreational use did not permit for the average consumer to grow cannabis in their home.
Great. And so you mentioned this, but you want to tell us again what the threshold is for the amount of cannabis possession in terms of getting things expunged?
Of course. So to cover that again, keep in mind it's misdemeanors and class 4 felonies. I bring up the class not to be very legally technical about it, but more so because there are some offenses that may have been amended to be a lower class of offense, and potentially that would still qualify. But generally speaking, it is possession up to 500 grams and manufacturer delivery up to 30 grams.
Great. And we've got a really good question here about how far or how old or recent does a cannabis conviction have to be to get to use this process or get it expunged?
The Chicago Police Department really hears from my staff quite a lot, and we regularly review records from the 70s and 60s. So pretty much if we can find it, there is no limit on how old that particular offense is.
Yeah, I think we had a client who had an arrest from the 70s. And so I think it's important to point out that the law actually did not provide any limits on how far back this went. So the idea was that everything that has happened that you can find and that you are still alive to care about could be expunged in this process.
And I will also note that in terms of just tracking down these records, it can be very difficult. And I think it's really good for the average resident to just know that these records exist in multiple places and they're not all uniform. So something that might be appearing on a local law enforcement criminal history report or rap sheet may not appear on a statewide report, and it may not appear in the clerk system. So there are a number of different places that these records can exist, and they're not all consistent. So really digging into what information is out there about you and how it's listed is really crucial.
Wonderful. And so, Regina, we've got a great question, which I think you'll start to glow when you answer, which is what proportion of Legal Aid Chicago's result in expungement? In other words, what is our success rate?
Well, I believe, what was it, 98, 99%?
Yeah, I think it's closer to 99% the last time we ran that data.
We ran that data, and I was surprised considering how anxious that some of us get when we get so many objections from the state on our petitions in general. But I'm very proud of my staff and just our team in general for the support. We've been able to get about 99% granted.
Yeah, and I think that there's a related question there, which is that are we screening for likelihood of success? Do we take everybody who comes to us, or are we only likely to take cases where the client is likely to succeed?
If you are eligible, I will take the case. I put no kind of merit-based limitations. I think that part of the intent of the Criminal Identification Act, which regulates expungement and sealing in general, in addition to the provisions for cannabis that were codified within that act based on the Cannabis Regulation and Tax Act, a part of that intent was to be as broad as possible, especially as you've seen the law change over the years, where there used to be significantly more restrictions as to the types of offenses that could be expunged or sealed. And with regards to things like wait periods, which used to be really significant. You used to have to wait like 5, sometimes 7 years for something to be eligible. And they also used to consider everything collectively, where if you had one conviction on your record, nothing, even non-convictions, couldn't be expunged. And we've really seen, even in just my 6 years of doing this, like a huge change in really allowing for institutional issues, poverty issues, race issues, additional context to be really factored in to really this very disproportionate system where our marginalized clients continue to be marginalized and disproportionately represented. And there are only a couple of things now that are not eligible for any type of relief, but long story short, if I see it, if I could do something about it, I'm going to try to do it, and I will prepare as best as I can.
Yeah, and I think Regina, one thing to point out in particular on that is that, you know, even if someone doesn't qualify under the narrow categories of, or what can be sometimes narrow categories under the Cannabis Act, they're still likely to be eligible for general sealing of their conviction or expungement of their petition, and so of their arrest or dismissal. And so we will take those cases again, as Regina mentioned, without regard to, you know, the merit. Will, if you are eligible under the law, and even if some of the stuff on your record is eligible and some of it is ineligible, we'll file what we can and represent that client throughout the process. And one thing that actually is wonderful to note here is that we are able to accept clients in this area without regard to income, as long as they're living in the state of Illinois. So some of our, and of course their record is in Cook County. And so sometimes our funders require us to restrict based on that, but this is an exception to that. So we can actually represent with regard to, without regard to income. Regina, so you want to go over again sort of how long it typically takes for a cannabis conviction to be expunged?
So there are a couple of things to factor in here. So what Melissa said is largely true. Right now, most of the cannabis motions to vacate and expunge, we were initially told to file them all regardless of what jurisdiction they're in at District 1, Chicago, which is 26 in California. And largely that has been the case where it's been added to a general backlog of expungement petitions that is about 12 to 14 months long, which means that you typically won't hear back from the court in that time. I will say, however, that because this has been brought up by multiple advocates, we're also exploring other alternatives and kind of doing our own thing. And I've noticed this amongst some of my colleagues in other agencies as well, where we've tried to file a couple of motions to advance on a couple of those cases. We have filed particular offenses just within that respective district. One of my staff attorneys simply asked the District 6 judge, for instance, if I brought this before you, this is my client's only cannabis offense that's eligible, would you hear it? He was like, sure. And we were able to get it granted. So I think that there certainly needs to be some more consistent practices when it comes to the frequency of these being heard and the timeline that this is actually taking place, because it's not immediately clear to everybody, where some are in this huge backlog of 12 to 14 months and some may be able to be pushed up. But I will still note that apart from cannabis expungement, there is still a general backlog for your standard sealing and expungement petitions in District 1, which means that you will likely not hear from the court for 12 to 14 months. And the other thing that you need to factor in is just when that 12 to 14 months runs, it doesn't mean that that's it, it's over. If you get assigned a court date, that might be another 2 months out. And then if and when it gets granted, that's usually another 90 days or so for agencies upon receipt, when they get the actual notification that it's been granted, to then actually expunge or seal those offenses. So there's something left to be desired in terms of the timetable, but if we can at least get that order from a judge, there are a couple of things we can do in terms of self-advocacy, in terms of trying to jump in and help people enforce their rights pursuant to the Illinois Human Rights Act as well.
Great. And so as we're approaching the hour, we will continue to take a few more questions, but I want to make sure I get this one, which must be a plant, which is the question: can lawyers volunteer with Legal Aid Chicago to assist in any part of the expungement process or assist in any given expungement proceeding? And gee, like I said, this must have been a plant question, but the answer is absolutely yes. You saw on the slide the link to our website, which lists all of our opportunities to volunteer, but one of them is with regard to criminal records relief. And so we have a training available that is taped and eligible for CLE credit. And we really do try to make this as easy as possible for anyone to volunteer as they would like. The expungement, the criminal records relief opportunity is limited to attorneys, unless of course you have an attorney to pair with a non-attorney. And so it's a super easy process. It takes about 3 to 4 hours, we think, per case, and that's probably a little bit high. We have a wonderful web-based application to help you prepare the petitions. And bottom line is we have a ton of clients who are in need of assistance. Those statistics that Regina mentioned about how often and how common it is to have a criminal record, and what she just said about how expansive the relief is, means that there's a ton of people who qualify for this relief and need our help. And so we welcome your opportunity to volunteer, and we are happy to work with you on what might work for your schedule to be able to do so. Regina, did you have anything to add other than, I'm so excited right now.
No, I think the other thing that I'll add is we do a lot of expungement clinics with pro bono attorneys, with various types of volunteers. And just to help anybody shake off the jitters, if you have no experience with criminal law at all, or with any kind of civil practice of this nature, rest assured, the training is pretty good, not to toot my own horn, but we are very good at following up with any of our volunteers to make sure that they understand the material. And we've really tried to package this in a way that you really just need that hour training to do, and a case file that we give to you that is just very narrowly tailored to just the information that you need. And in just that time, you can make such a significant impact. Melissa is right. We do not have a shortage of clients ever. And so really having that pro bono time dedicated to our clients in this manner, it helps significantly so that we can represent more clients and we can intake more clients, because there's a lot more work to do, like we said.
Great. And so, Regina, really good question here about how often the state files an objection, either to motions to motions to vacate and expunge, or to regular expungement petitions and expungement and sealing petitions. And then if you have any information about how often the court might deny after an objection.
So with regards to cannabis motions to vacate and expunge in particular, so far, and again, in terms of new law, new court procedure, we're still pretty much in the early days, especially considering how long it took anybody to be able to file one of these. Really, the only objections that we have seen so far have been with regards to any kind of technicality. I have yet to see a public policy objection, which is the most common type of objection for us, with regards to cannabis expungement in general. With regards to just your average petition to expunge and seal, we were told 50% of the time the state is objecting, and it feels about right. Again, on the basis of public policy, which is very much this very subjective kind of catch-all where the state believes that the nature of the offense or the time since the offense, any details of it are particularly troublesome. So they regularly object. Our personal success rate in terms of overcoming those objections is relatively high. And we usually have a good idea of certain records, certain petitions that are going to be an uphill battle, but that's part of the goal of the full representation that we provide, is really making that assessment up front to try to be as transparent with clients as possible so that they understand that unfortunately expungement and sealing is not a right. It is still subject to a judge's discretion. And judges are people, and they have their own biases and beliefs and things that they feel that they're not comfortable touching at this time. And so it may be difficult for some. Our success rate is pretty good. That may not be true for everybody, especially for people who are unrepresented. I really need to highlight that, where the law is complicated, it is not particularly informative as to what to expect at a practical level with regards to showing up to court, how to get mitigation evidence to the judge, and really what is expected of you in terms of what to say and what to argue. It can often feel like a character attack, and that's something that I really emphasize to my staff that they need to prepare their clients for if the client is required to appear. So in sum, it happens all the time. Objections are extremely common, usually only from the state's attorney's office, but we will do everything we can to try to remove that barrier as well.
Yeah, and I think the other thing that's important to mention as we discuss this is that our experience is limited to Cook County courts, and there are other counties, well, there are obviously other counties in the state, but we have heard from some of our colleagues that the rate of objection, that the judge's discretion is exercised differently in other parts of the state. And so what we're speaking of is our experience in Cook County in particular. And not just, of course, Chicago, but all of the districts in Cook County. Okay, Regina, the question is about how an expungement or sealing might affect federal records.
Oh, federal records. So federal records don't always appear on state records, even a statewide police report. And so sometimes they creep up. Here's what to just understand. Federal records are their own separate category that really, if you have a federal conviction, the only option really is to get a federal pardon. Now, in terms of how these records interact with each other, if I'm understanding the question correctly, with a federal record, it's important to understand that it can impact your eligibility for expungement and sealing in general, because for expungement and sealing in general, the law says that we have to factor in any conviction in any jurisdiction for the purposes of determining if a client is subject to a wait period to seal convictions in particular. In terms of just the existence of these state records in general, they could impact your federal case if they still exist. And in general, that's something that can be factored into things like sentencing. I believe I think I answered the question. If not, I'm happy to elaborate a little bit more.
I think, Regina, in particular, one of the concerns is that if you have a state-based conviction, that might be reported, for example, to the FBI, and that it might come up on a different type of background check. If you can elaborate on that as well.
So some offenses, specifically things like felony convictions, will be forwarded to the FBI. Like I mentioned, it can be very difficult to really fully understand which agencies, which bodies, which platforms really have what types of records. But for instance, not everything is required to be reported from the local level to the Illinois State Police. And things that are actually with the state police do generally get forwarded to the FBI. But it's really just a very messy chain of record information sharing. So it could exist at the FBI level as well, and certainly very accessible if nothing has been done to expunge or seal it.
Great. And I think this will be the last question before we close up, which is about public policy or other objections to cases where the petitioner has a positive hit for cannabis and only cannabis on a drug test. And so we should zoom out. This particular question is from somebody who's very knowledgeable about the law. Typically, when you're seeking to seal a drug-related conviction, you do have to submit a clean drug test to the court along with your petition. And so actually, there's a recent development here, Regina, that I'm hoping you'll talk about as well.
Yes, I forget the exact number of the bill, but it's a bill that passed both houses and is just awaiting the signature from the governor that more explicitly states that a petition cannot be denied solely on the basis of having THC show up on a 5-panel drug test that is required to be submitted when someone is trying to seal other drug-related convictions.
Great. And
That's
so
we're in good shape.
Yeah. Great. And so I think that's all the time we have for questions today. And so, John, if you want to close us up.
Thank you, Melissa. I really appreciate your presentation. I appreciate Regina's work in this space, both of your work. And we're hopeful that many of you on the call here today on the Zoom will consider volunteering with us and advancing the cause here. So, next week, please join us for our session on building legal services for homeless clients. It should be another great session. We look forward to your joining us next week. Thanks for joining us today, and thanks to our sponsors for supporting this effort. Thanks, everyone.